Hi, everyone. As promised, today we're going to be talking about TRESA. As you know, TRESA has came into effect on December 1st, and today is December 2nd. So we are going to talk about the details of the act and also how it's going to affect your business. So let's get started. All right, what's TRESA? Okay, we know that TRESA is the replacement of RIBA, Real Estate Business Broker Act. And there are some changes that are coming with this new release or second phase of TRESA. TRESA was basically released in three phases, and it's called TRESA 2002. It's funny that we had RIBA 2002 rather than changing the name to a different year. They just kept the 2002, and now it's called TRESA 2002. There are three phases. One of the phases was done a while back, and if you remember, uh, basically the phase one uh, allowed personal real estate corporations or PRECs. So a lot of you have enjoyed that. You opened your PRECs, and you are basically taking advantage of that change that happened. Also, the phase one allowed real estate professionals to use a different type of terminology for their title, including agent and realtor, that now is being used by the real estate professionals in Ontario. Now, let's talk about phase two, which was December 1st. As of December 1st, there have been changes to Code of Ethics and RICO's Discipline Committee basically process. As you see, we have seven changes on the screen. There was also brokerage representation versus designated representation. The third change was self-represented parties or SRPs. We're not going to have any more customer service. So customer service ceased to exist as of December 1st. And now you could provide some services, very minimal services, to self-represented parties. Also, RICO Consumer Information Guide is a new guide that has to be used by real estate professionals. And this is the first thing that they do, whether they work with a buyer or seller or any third party. And it is important to understand that this guide is mandatory now. Multiple representations, there has been some changes to that, and we're going to talk about that. And also sharing content of the offers by the seller, which is a big change, and we'll discuss that in detail. Now, we're also going to talk about agreements, the existing ones, any future agreements that you're going to be doing, and some key contents that we have to pay attention to while we're working with these type of agreements. So let's start. But before we do that, let me just tell you that phase three of TRESA is coming in 2024, and that's going to address specialty designations, including commercial brokerage designations. We don't have any details. We don't know how they're going to process that, if it's going to be a mandatory designation that you have to get or not, but we're going to get more information from RICO soon. All right, December 1st, it's already here. Okay, as of today, you're not able to use the previous forms anymore. There are new forms that have been released by OREA and real estate boards, and it's mandatory for you to switch to these new forms. That's why if you're working with any brokerage, they're probably not going to accept any of the old forms if you use them to do the transaction. Any previous transaction that you've done is fine, but anything new has to be done on the new forms. Okay, so let's start with the first topic, but understand that there are some gray areas with TRESA. First of all, the rollout was delayed. Initially, it was supposed to be months ago, and then RICO and OREA decided that, mainly RICO, decided that they're not ready, they don't have the proper forms, they don't have the proper procedures, so they delayed it. But the funny thing is, although December 1st was the start date, the forms were not available until November 29th, meaning that they only gave everyone a couple of days to implement all these forms. And that's why I think it's going to take some time until we see things roll out properly. But that's not an excuse. You do have to make sure that you are following TRESA immediately as of December 1st. And understand that all the systems that we're using, any electronic signature platforms, they are trying to update these systems. It might take them a bit of a time. So don't be surprised if the old forms are still there, and you can communicate with any platform that you're using and make sure that they have updated their forms and you are actually using the new forms that are required to be used. Okay. Now, phase 2 deals with code of ethics. The old code was a mix of principle-based rules and technical requirements. Old code was quite lengthy. There were 54 sections, and it was pretty confusing. So members had a tough time understanding it. The updated code retains the ethical requirements and moves technical and procedural requirements to regulations. New Code of Ethics uses broad principles and is much shorter than the previous one. It's only 16 sections and a lot easier to understand. So that's an improvement. Now, it is common sense that, because it was so confusing, we had to make some changes. And this aligns more with our core values at the brokerage as well. So let's just have a look at some of the things that are introduced. Most of the sections are not new, but they were just paraphrased. For instance, you're not supposed to participate in any fraud. You got to comply with human rights code. You got to protect best interest of the client, and you got to disclose any item that's important to all the people that you deal with, and all the pertinent facts have to be explained to the clients before they get into agreement. You got to provide conscientious service, and you got to keep client information confidential. You can't share that with anyone else. Also, you got to communicate to clients only through agents, meaning that you still have to go through the other party's agents to communicate with the clients, and ensure that brokerage complies with TRESA, especially broker record of the company, obviously has to be aware of TRESA and follow the rules and regulations. Okay. All right. So there are 3 sections that are very important in Code of Ethics. Section 8, 10, and 13. Section 8 is consumers' ability to understand. Section 10 is self-represented parties and deals with those type of individuals. And Section 13 is conflict of interest. Now, one thing that I strongly suggest is that read these 3 sections of the Code of Ethics, and make sure that you have a clear understanding of these 3 sections. Now, let's talk about RICO Discipline Committee and what changes have happened to that, okay, and how we're going to deal with that. Basically, they have new powers. Okay, RICO can now refer a matter to a discipline committee, whether there is a formal complaint or not. Before, they had to deal with complaints. Okay, so if consumers or other realtors or brokerages filed a complaint, then RICO looked into it. Now they don't have to wait for a complaint. If they see something wrong, they can come after you. Now, the fines are also has increased. For agents, it's up to $50,000, and for brokerages, fines are up to $100,000. So you got to be really careful, because these type of fines are not easy to navigate or pay. They can also revoke or suspend agent registrations or apply any conditions that are required. And finally, you got to disclose to the public information about the registrant and any type of basically disciplining action that's done against them, including revocation or suspension of registration. I think media is going to have a lot of fun with this, because I think now that RICO is going to disclose all the details, you're going to see a lot of articles popping up in media. Okay, so careful if you care about your reputation. Now, let's have a summary of the Code of Ethics. The Code of Ethics addresses about 90% of the problems that we saw at the brokerage level. And you got to be very careful and read the code truly and make sure that you don't make any mistakes because it's going to cost you money and a lot of pain. Second topic is brokerage versus designated representation. Brokerage representation is basically impossible in large brokerages. And the reason for that is because if you have like 1,000 realtors in a brokerage, how can you understand that if there are like 20 offers on a property and a couple of people from that brokerage from different offices are putting those offers and the listing agent somehow misses it, then you can't really inform your clients about basically this issue. So that's why the multiple representation was very hard to navigate in these brokerages. Because of the obvious impossibility, most of agents typically behaved as designated representatives, not the brokerage representatives. To deal with these challenges, TRESA introduced the concept of designated representation, which is very important. Now, under the designated representation, a specific agent or agents are designated to provide service to the client. The designated representative is the only agent responsible to protect and promote the best interests of the client, and designated representative is also responsible for protecting the confidential information of the client. So it's no longer the responsibility of the brokerage, okay? Now, under this designated representation, confidential information cannot be shared with anyone at the brokerage, meaning that if you have colleagues in the brokerage, you cannot share the information of your client with them, unless you put them as part of the agreement and have them listed as one of the agents that are going to provide service to them. Designated representatives should not share certain information in the case of multiple representation. For example, client motivation to buy or sell, client personal or financial circumstances, minimum price that a seller would accept or minimum price that a buyer would offer to pay. Or maximum price that a buyer is offering to pay. Now, in terms of documentation, under the designated representation, the representation agreement or BRA or listing agreement, so you either have a buyer or a seller, remains with the brokerage. So you still have to provide a copy of the document to the brokerage. The only difference is that agreement identifies the name of the agent or agents as the designated representative for the client. Otherwise, the forms are basically the same. And we're going to talk about the forms shortly so you can see what we're talking about, okay? All right. So, as I mentioned, we're going to discuss the forms at the end of this session, and you're going to be able to go through that and have a look at all the forms that we're going to be discussing together. Now, company policy. Here at Homila, we're going to move forward with only designated representation, because there's no a logical reason for you to sign the client up with the brokerage, because you're the one that's going to provide the service to them. There can be more than one agent or the team representing the client, meaning that you can list everyone that's going to provide service. If you're working with a team, list everyone in the team that's going to provide the service to the client. And the only time that I think like a brokerage representation might be a good idea is when you're dealing with a PREC. If any of you have registered a PREC, then you can put the brokerage's name in there. And that way, everyone at your brokerage, if you have an assistant and yourself and maybe a buyer agent, all of you will be able to provide service to that client. Summary of designated representation. Designated representation is the best option for our agents. Agents must act consistently, including consistency in all their documents. And please contact us if you have any questions about designated representation. Now, next, we're going to talk about RICO's Consumer Information Guide. and you see a screenshot of that on the screen. This document is available on Ricoh's website, and I'm sure over the time you're going to see copies of this popping up on all the platforms that we are using. But currently, if you need a copy, please get it from Ricoh's website. Now, Ricoh Consumer Information Guide or Guide says that regardless of which method of representation you selected, Ricoh has mandated that all agents provide a consumer Ricoh information guide or a guide, and this does not replace the working with a realtor. So you have to do this first, and then you do all the documents that you used to do before. The agent must discuss this 11-page guide in detail and make sure the consumer understands the concept contained in this guide. After the consumer understands what agents do, they can execute the guide and be provided a copy of the guide. And it's important for you to provide them with a copy. Registrars must provide consumers with a copy of the guide and shall explain the content of the guide before they provide any service. Okay? Also, before they enter into agreement with the client or provide any assistance to a self-represented party. The only permitted version of the guide is the one that's on the Ricoh's website, and you cannot alter or modify this guide in any way. You cannot decide that you're going to cross out a section of it or add something to it. This is not allowed. So the guide has to be used exactly the way it looks on Ricoh's website. All right, so information guide. What does it address? Okay, the content of representation agreement with the brokerage and the key provisions to consider, meaning that scope of services, how long the agreement lasts, whether you can cancel or terminate the agreement, remuneration, and what might cause compensation to change. In other words, if the commission is changing, what's the reason behind it? Deals with multiple representation and also changing your designated representative, meaning that if the client wants to change that designated representative. Now, there's a section, and that's the fun part, that talks about how to bring the client's concern to the attention of the brokerage or how to complain with Ricoh. So it gives them the guidance to start a complaint with Ricoh. All right, so if someone refuses to sign, every consumer must get a copy of the guide, even if the consumer refuses to sign the guide. If consumer refuses to sign but signs a representation agreement, meaning that they say, hey, I don't want to sign this guide, but I want to sign a buyer agency agreement or a listing agreement with you, the guide should be provided to our accounting for processing. And on the guide, you should write the name of the consumer and your name, the date that the document was provided and discussed with the client, and a note that the consumer refused to sign the document. So you still need a copy with all those details basically submitted to our accounting department. Summary. Registrars must provide consumers with a copy of the guide and shall explain the content of the guide before providing any service. The only permitted version of the guide to be used is prepared by Ricoh. No modification is allowed. And you must provide signed guide or a copy with information of the consumer that refuses to sign the guide before you can get paid from the accounting department. Self-represented party is the next topic that we're going to talk about. As I mentioned at the beginning, the customer services no longer exists, and you cannot sign anybody for a customer service. The clients are the ones that you have an agreement with, and if you don't have an agreement with someone, it's called a self-represented party. So they're representing themselves, and the short format for that is SRP. A self-represented party is not a client of any brokerage, and therefore they're not subject to any type of agreement. In contrast, a consumer who's working with an agent must have a representation agreement of some kind. Okay, so they have to sign something. A representation agreement is either a BRA, a listing agreement, or a limited service agreement. That's a new form that we're going to discuss in our next videos that comes out. But basically, those are the three options that you have. Now, agents cannot provide any services to an SRP. That includes usage of agent's skill, knowledge, or judgment. And the services must be incidental to a client of the brokerage, meaning that the only time that you can provide a service to an SRP is when you're servicing your client. An example of it is showing a property that you listed. And if someone wants to see that property and they're not represented, they're self-represented party, then you can still show that property to them. Now, self-represented parties are not entitled to any of the services that we listed here, and it's not limited to these, meaning that you pretty much can't do anything for them. You can't prepare a CMA, you can't select properties to show, you can't decide what terms to offer, you can't draft the agreement of purchase and sale or any other document for them, you can't provide advice on how to list the property, you can't advise on which properties to buy, and you cannot determine how much to offer or accept. And as I mentioned, this is not the list. There's much more that you can do for them. My guide is if they haven't signed anything, then you can't provide any service to them. Unless by providing a service to them, you're providing a service to someone else that has a contract with you. Okay? All right. Things that you can do. An agent is permitted to provide a SRP with the following services. Sending feature sheets on a brokerage's listing, meaning that if I have a listing, I can provide the self-represented party with a copy of the listing. Communicating publicly about available data related to that listing. And also you can show the brokerage's listing. And as I mentioned, these are all services that you have to provide to your client. So that's why these are permitted under the Act. Before assisting an SRP, the agent must review and have the consumer execute both pre-close information guide, the guide that we talked about, and also an information and disclosure to self-represented party form, which is a different form. And we're going to talk about it later in our form section. So two documents have to be signed by the SRP for you to be able to provide any of those services that we discussed as well, okay? If they don't sign anything, you cannot provide any service whatsoever. All right. This is a copy of the information and disclosure to self-represented party that you see here. There are two versions of this, by the way. There's a designated representation version that you see on the screen, and there's one that deals with the brokerage representation. So depending on what type of agreement you have in place, you have to use the proper form. All right. Now, let's talk about information and disclosure to self-represented party and what that form contains. It explains what it means for a brokerage to represent a client in a transaction. It also talks about an explanation of the risks to the party that may arise from not receiving assistance from the brokerage. It has a recommendation that the parties seek independent professional advice, and also regulation request a signed copy of this document. So even if they don't want to sign an agreement with you, they still have to sign this document before you can provide any service. And I said that a couple of times, this third time we're talking about it, it is important for you to have a signed copy of this document. Now, if an SRP refuses to sign either of these documents, you cannot provide any assistance. Keep that in mind, okay? You're going to get into trouble. You're going to basically go against the Act if you provide any services to these parties if they do not sign these documents. Now, let's summarize. Self-represented party. Most consumers want to be represented. You can do almost nothing for an SRP. If an SRP refuses to sign either document, the agent cannot assist this consumer in any way. And if you're in doubt, just contact one of our managers and or myself, and we'll be more than happy to discuss that with you and make sure that you don't make any mistakes. All right, multiple representation. There's another change in regards to how we handle multiple representation, but let's talk about multiple representation first. Multiple representation means a designated representative or a brokerage which represents more than one client that are competing, they have competing interests in the same transaction. So me as an agent, if I have two clients that they both want to put an offer on the same property, or if I have a buyer and seller that they want to do a transaction, because I'm representing both of them, I'm in a multiple representation scenario. Remember, with the new regulation and TRESA, if they are designated representative, even though they're coming from the same brokerage, they're not in multiple representation scenario. So it does not occur if two agents from the same brokerage that they have designated representation dealing on the same agreement or scenario, you do not have to worry about multiple representation. Okay. All right. Disclosure requirements for multiple representations are not new. We had to disclose when there was multiple representation. Under REBA, the client was told that it might occur at some point, but no additional disclosure document was needed when it occurred. They just had to initial a section in the agreement to consent, but apart from that, they didn't have to do anything else. Now things have changed. The timing of the disclosure and consent is different. There's a new form for the disclosure, and it has to be done prior to submitting the agreement. So it's very important for you to discuss this form with them and get their signature before you act for them in a multiple representation scenario. No agent can submit an offer until both parties or all parties that you're representing have understood and consented in writing to multiple representation. The agent 325, Form 325 is the new form for the sellers, and Form 326 is the new form for the buyers. Okay, so it's important for these forms to be used and to be submitted to the client prior to signing the agreement. Agents cannot take any further steps on behalf of either client until the disclosure is made and both consent in writing. If consent is not granted, if one of the parties decides that they don't want to allow you to act in a multiple representation scenario, the transaction cannot proceed. Or what you can do is you can cancel your representation agreement with one of the clients and just represent one of them. The other client has to be represented by someone else. Either someone else from your brokerage, if it's a designated representation, or they have to use another brokerage if it's a brokerage representation. That's why we suggest to use designated representation in all scenarios. Now, permitted services. Nothing has changed. Assuming both parties agree to multiple representation, you must remain impartial, do not share any confidential information, and can only provide limited services and cannot provide advice on price and terms of the agreement. Let's talk about the forms at the end, and I'm going to talk about the forms that you require for this and also how to fill them up. Summary. Multiple representation does not occur if two clients are represented by two different designated representatives at the same brokerage. Agents cannot take any further steps on behalf of either of the clients until the disclosure is made and both consent in writing by signing the new form. If either client fails to consent, agents cannot proceed with the transaction and must cancel the contract with one of the clients in order to proceed with the other client. Again, if you need any further information, please contact one of us and we'll be more than happy to discuss this further with you. Let's talk about sharing content in a multiple offer situation. That's a controversial section of the act that a lot of people are talking about, and we're going to try to clarify it for you. Under TRESA, a seller can elect to share the contents of competing written offers at any time during the negotiation process. Okay. In other words, is they can choose to share the information. They don't have to. Plus, they can change their mind at any point. Okay, they can say, "Hey, listen, I'm not going to share any information," but in the middle of the negotiation, they decide that, you know what, I'm going to do it. Example of content that can be shared are price, closing date, deposit, etc. Contents must be shared with other people or the agent that are making one of the offers. So you can't go and share this information with others that are not party to this multiple offer scenario. Now, personal information that can be shared cannot be shared. In other words, anything that can identify a client, including name, address, or other information, cannot be shared with the other party, meaning that all the information that you're sharing is anonymous. You can't say, "Hey, Mr. Joe Smith put the offer on our property and this is the price." No, you cannot name the people that are putting an offer. If you're acting for the seller communicates its decision to share offer details using a new form called Form 209. It's called Seller Direction to Share Substance of Offer. Make sure you get this form signed before you share any information. The seller can change their mind during the process, as I mentioned, and they could tell you in the middle of the negotiation that now they decided that they want to share that information. If that is the case, it is important for you to follow a certain procedure, and we're going to talk about it. Okay? So, if you're acting for a buyer may not want to proceed with a scenario, meaning that if the seller says, "Hey, I'm going to share this information," the buyer might say, "Hey, you know what? I don't want to be party to this. I don't want to get involved." The buyer agent must communicate with the buyer in advance regarding their decision to proceed or not. Okay? And the buyer's agent must communicate with the listing agent if contents of the offer are being shared. So as soon as you find out, you tell your buyer, and the buyer decides if they want to move forward or not. The buyer agent must inform the buyer of their options and confirm in writing, meaning that you got to either get an email or a text from the buyer before proceeding with the offer. Now, there are some problems. A seller has agreed not to share content of an offer. All of a sudden, in the middle of the negotiation, as I mentioned earlier, changes their mind and wants to disclose the content of competing offers. The form, first of all, must be signed. So their agent has to put the form in front of them, and they have to get the seller to sign it. Then the listing salesperson has to contact everyone before the next basically round, or before the next set of information is disclosed to everyone, and tell them that this is the scenario, and they're going to start sharing the information, and those parties might not want to proceed with their offers. Now, think about a scenario where you have 20, 30, 40 offers. We had situations like that. Now you got to call 40 people, or you got to communicate with 40 people. Right now, the technologies that we're using does not have anything that would allow you to resolve this scenario. But I'm sure a lot of the companies are planning to include this technology. And over the next few weeks or months, we're going to be able to see some of these products have that option of communicating with everyone and letting them know that they're going to share information, and also share that information at once with everyone. Also, in regards to the sharing of information or content of the offer, there's a major problem with commercial transactions, which we're going to try to discuss at a later time. Okay. Now, if the buyer does not want the content of the offer to be shared, how do they stop it? Okay. ORIA is sharing a clause soon that is going to allow the buyer to revoke the offer if the seller decides to share the content. But to protect the buyer, we already have a couple of clauses that you can insert in the agreement to void the offer if the seller decides to share the content. The first clause that I'm going to discuss with you is going to be basically the automatic termination clause related to sharing content. As you can read on the screen, it says the seller agrees to hold the content of this offer confidential and not to disclose it to any third party, the content of this agreement, except to its professional advisors who has a need to know such information in furtherance of the transaction contemplated hereby. And in the parentheses, we have, and whom the seller shall require to abide by the terms of this provision. If the seller discloses to a third party the content of this agreement in breach of its agreement herein, this agreement shall immediately terminate, and in such event, the deposit shall be returned to the buyer without deduction, without prejudice to any claims that the buyer may have against the seller arising out of the breach of the seller of these provisions. So basically it says that the agreement is going to be null and void if they decide to share the content. Now, if you go to the second clause that we have, this clause gives the buyer an option. So literally, the only difference is in the middle of the clause that says, if the seller discloses to a third party the content of this agreement in breach of its agreement herein, the buyer shall be at leery within 5 days after the buyer learns of the disclosure by the seller to terminate this agreement upon delivery of written notice by the buyer to the seller, and in such event, the deposit shall be returned to the buyer. Meaning that I have the option to literally cancel or decide that I'm going to proceed with this agreement. Okay, so it's important that now the buyer has that option, and not only they have the option to cancel the deal within 5 days, even if their offer gets accepted. I mean, I see that some of the sellers might have a tough time accepting this. They might limit it to a shorter period of time, or just give them the option of either proceeding or not proceeding. So this is purely in favor of the buyer. And if you are representing the seller, you probably don't want to accept an offer with this, because it gives them a wide range or time frame to cancel the agreement. Okay. All right. So for large commercial transactions, due to high risk, you must get separate form of confidentiality signed with the other parties, so the information is kept confidential. And you should change your confidentiality agreement that you generally use to include the offer content sharing as well. So if you generally have a confidentiality agreement, you got to tell them that, hey, this also applies to sharing any information on my offer, and that way you're protected. Because in large commercial transactions, I don't think the buyers want to share the information with other parties. Now, sharing content of multiple offer, let's quickly do a summary. The seller must communicate its decision to share offer details using Form 209. It's called seller direction to share substance of offer. The buyer must decide and communicate if offer details can be shared and what the seller intends to do before submitting an offer. If the buyer does not want to share offer details, agents must insert clauses preventing that from happening, and that's those clauses that we discussed earlier. Timeframes. Existing client representation agreement entered into before December 1st will remain in full force and effect until the expiry, meaning that if you signed agreements before December 1st and they were accepted, you don't have to make any changes, okay? You can still use those forms. After expiry of existing client representation agreement, new forms must be signed to enter into TRESA designated representation and continue the relationship. So you have a buyer agency agreement, it expires next month, you have to sign the new form. You can't continue to use REBA forms, okay? In regards to customer service agreement, we said that it doesn't exist anymore. If you have one that was signed before December 1st, they will still stay in effect until the expiry date or March 30th, 2024. Meaning that once March 30th, 2024 comes, all those agreements are void, null and void, okay? So keep that in mind that if your expiry is past March 30th, 2024, on March 30th, 2024, they're going to expire. Okay, so you might want to change those customers to a client, or on March 30th, you got to let them go. All right, so in regards to the content, effective immediately, you must use the new forms. For any deal already written before December 1st, 2023, you don't need to make any change. So all the agreements of purchase and sale are still good if they're written before December 1st. Make sure you update your transaction templates. If you're using any templates in any of the technology platforms, web forms, or any other technology platform like SkySlope, make sure that those kits have new forms in them. Just because you had a kit made last year and you did not update the forms, it's not an excuse for you to not to use the new forms. So make sure you update the kits. The agreements must contain the services that the brokerage will provide under the agreement, the terms related to the termination of the agreement, if any, no verbal agreements allowed related to termination or expiry. Okay, so those are some of the changes that are happening to the new forms. The agreement only contains one expiry date, and the buyer or seller must initial next to the expiry date. Okay, I'll show it to you on the forms when we discuss the forms, but it's important to understand that these minor changes that have happened are very important. Also, all representation agreements must clearly and comprehensively and prominently set out in writing, in case of a listing agreement, remuneration payable to the cooperating brokerage, circumstances in which remuneration payable may change. For example, if you're in a multiple representation scenario, or if you're assisting an SRP, buying or selling for the same client, all of those scenarios have to be indicated in the agreement, and you have to put it in writing. You can't just tell the buyer, hey, listen, if you buy a house from me, I'm going to reduce my commission, but don't put it in the agreement. That's not allowed. Okay. The other thing that you have to keep in mind is that when you're assisting an SRP, you have to put in your agreement that what sort of commission you're going to charge if a SRP basically is party to the transaction. Verbal offers are now a breach of TRESA. All right, so summary. All existing customer service agreements will expire on or before March 30th, 2024. After December 1st, 2023, you must use new forms. The brokerage will not accept new deals with old REBA documentation. All representation agreements must clearly, comprehensively, and prominently set out in writing how the compensation will be calculated. That's a summary of our agreements. So we talked about a few documents. You see the guide on the left-hand side. The information and disclosure to self-represented party is the middle form that you see here. And we see a copy of Code of Ethics on the right-hand side. These are the documents that are very important for you to review and read and make sure that you have a clear understanding of all of these documents. Now, in regards to the forms, these are some of the forms that you should be aware of and make sure that you have a clear understanding. The information guide, the 11-page document that has to be reviewed by everybody that you're dealing with, and they have to sign it. There's no exception, okay? And we talked about the fact that if someone doesn't sign it, you have to make a note of it, put their name, your name, and the date that they refuse to sign. The information and disclosure for self-representation party, both of these documents are important to be signed by SRPs, otherwise you cannot provide any service to them. Form 325 is for the disclosure of multiple representation to the seller, and Form 326 is the disclosure of multiple representation to the buyer. We use Form 209 now to allow sharing of the content of the offer in multiple offer scenarios, and this form has to be signed by the seller. Working with the realtor has some minor changes, and also there are minor changes to the listing agreement and buyer agreements. And finally, the confirmation of cooperation now has 3 pages, but the content is pretty much the same. So there are no changes there that you should be worried about. All right, so let's have a look at these forms. We talked about the guide. So this is mandatory. Everyone has to sign. In regards to the information and disclosure to self-represented party, we told you that both of these forms have to be signed. Otherwise, you can't work for them. The Form 325, or the form that the seller has to sign for multiple representation. This is the new form that we were talking about. This is mandatory to be signed by the seller prior to the presenting the offer. There are several different scenarios, as you see, and the seller has to initial beside the one that applies to that specific scenario. We're going to have additional training for these forms, and you got to make sure that you are selecting the right option. If you're in doubt, contact your manager and we'll be able to help you out. But keep in mind that this is mandatory now prior to presenting the offer. For the buyer, we have a similar form. And again, multiple sections that you can choose, and you have to make sure that you select the right option before presenting the offer, and the buyer has to sign this. Now let's talk about Form 209. This is mandatory when seller decides to disclose information for a multiple offer scenario. Get it initialed on all items that should be shared. So as you see, there are multiple items on this form, and you have to put an initial beside all the items that you want to share. The items include price, the amount of deposit, conditions, closing date, and you can add other items as well, but keep in mind that nothing personal can be shared. So you cannot put like the name of the buyer and say, hey, I put it in the other section. You can't do that. No personal information is allowed. Now, let's look at the working with a realtor. From a seller's perspective, when you're filling this up, you see that we have a new section on the left-hand side that the seller has to acknowledge or initial, and you would put the name of you would put the seller in this section. You can select buyer or seller. You put the seller in this section, and you get them to initial right beside it. This basically says that they acknowledge that they have received a copy of the information guide. Okay, this is mandatory. You have to get this done on all the forms. The only difference is you're going to put either buyer or seller, but they have to initial this section. Okay. All right. Now, there's also another section at the top right corner. If working with a self-represented party, there's a new section that basically you need to fill up indicating that they received a copy of the self-represented party acknowledgement form. This is only when they're self-represented, and that is why you have to make sure that this is filled up when you are working with a SRP. And in this case, we have a seller. Now, in case of a buyer, obviously, you're going to put buyer in that section. Okay, now in terms of the listing agreement, now you have to fill up the designated representation section by adding your name in that big box at the top. So that's the name of salesperson or broker or brokers or a group of people that are going to provide the service to the client. Now, expiry date must be initialed now, regardless of the length of contract. We used to initial it only if it was less than more than 6 months. Now, doesn't matter how long it is, it has to be initialed. And we had the other box, which dealt with the fact that they did not sign any other agreement in the past. That's also has to be initialed. So a couple of initials there with the name of the sales representative at the top. If you miss writing the name of the salesperson in the top, it automatically makes it a brokerage representation. This is not recommended. Please don't do it, okay? All right, I'm going to quickly show you the version for the buyer. Still, if it's a buyer, you have to fill up the box at the top left corner that they have received a guide. And also, if they are a SRP buyer, then you have to fill up the section on the right-hand side and get them to initial as well. Now, in buyer representation agreement, we pretty much have the same thing. You have the designated representation, which you have to fill your name in. And then you have the duration or expiry date that has to be initialed now. It's mandatory. And then also the fact that they don't have any other BRA with any other agents. And once again, do not forget your name, because that's going to make it a brokerage representation. And we are trying to stay away from that. Additional points that has to be addressed. Consumers who attend open houses are not required to complete the RICO information guide. If they simply walk through the property and they're just asking for information. Before an agent starts providing advice, opinion, or insight on the market, now the guide has to be signed. But if you're just providing a feature sheet and they're just walking around in the house before you give them any advice, then you're not required to give them the guide. For any open house conducted by the agent of the brokerage, all the normal feature sheets and other marketing material can be provided without having to review the guide. And also, agents can continue to do open houses for other agents at the brokerage, as this is a service to our client, the seller. The agent conducting any open house would be subject to the same rules regarding providing advice, opinion, or insights on the market, which would require completing the guide. As part of an agent marketing effort, you are permitted to share general public information for consumers and prospective clients, and all that information should be publicly available from other platforms. A representation agreement is not required to share publicly available information, okay? And finally, number 4, contacting past consumers and providing publicly available real estate information, including sold prices, would be acceptable. Should the agent start communicating with the prospect and providing advice, opinion, or insight, now you got to show them the guide, get them to sign the guide, and then get them to select what type of relationship they're going to have with you. The only option is client, remember. Okay. And number 5, contacting past customers and providing a real estate review or the CMA would be acceptable, as this would suggest an ongoing agency relationship or implied agency. In this light, the agent would be required to meet the code of ethics requirements with respect to these clients. Okay, I hope that clarifies TRESA to an extent for you. We're going to probably have additional training in the office for you in regards to the TRESA. If you have any questions, feel free to contact me directly. My cell phone number is 416-917-1414. And if you want to reach out to me via email, it's ray@homula.com. Have a wonderful month, the rest of the month, and start of a great new year. And remember that TRESA is now in effect, and you are mandated to follow all the rules and regulations and use the new forms. Take care. See you next time.